Hello, and welcome to this webinar today on prosecutions and injunctions. My name is Craig Allison. I am the Vice Chair and the NAPE North Representative of England. I'm also a Senior Planning Enforcement Officer at Hambleton District Council, and I will be chairing today's webinar. Today we are joined by Scott Stemp, who is a nationally recognised practitioner in planning law, who regularly advises and represents developers, local planning authorities and objectors on a broad range of planning matters, and at all stages from pre-application advice through any appeal processes and to the Court of Appeal. He has extensive knowledge of all planning enforcement and in particular enforcement and environmental prosecutions, statutory nuisance and proceeds of crime. Scott will be talking to us today about prosecutions in regards to the authorisation of prosecutions and confiscation under POCA, which is always a interesting topic that us enforcement officers want to know about POCA and how we can utilise it and try and get as much money as we can for local authorities effectively. There will be also a disclosure of materials for prosecution, which obviously I've listened to Scott's talks a number of times and I've heard the mistakes that other people have made, and I don't want to do them myself, so it's always interesting to hear that. And also talk just today about injunctions, about the post decision on the recent Bromley decision as well, so that'd be interesting to hear. You should also be able to, Scott's not actually doing like a full-on PowerPoint presentation today, he's just talking to us. There is a handout that is prepared for you all to sort of download, which you should be able to just see above the question section and be able to see that. That is purely the verbatim notes, and there are a summary of his main parts of his talk today. Obviously, there'll be a Q&A session at the end, so if anybody's got any questions as to things going through, pop them down and we'll try and get through as many as we can at the end of the session. So I will now pass over to Scott to start his talk to us. Thank you very much.
Thank you, Craig. As Craig mentioned, no slides for you today to look at, but there is a handout prepared for you, which you will be able to download now, in fact, from the GoToMeeting app, either by the question mark, I think, or underneath the handout section. It is not a complete collection of these speaking notes, but what it will do is summarize for you what the main points are that I'm going to be talking to you today about. I'm going to talk two main areas, prosecutions and injunctions. And I'm going to talk to you on prosecutions about two areas of continuing interest, but both of which arose recently in a High Court case by the name of Kombu. And then injunctions, we're going to turn our attention to asking, where are we with injunctions? Post the Court of Appeal decision in Bromley, and we'll consider the Bromley decision and some of the implications of it in practice. So the first of those, prosecutions, we're turning to a case called Kombu. It's the Crown on the application of Kombu against the Crown Court of Wood Green. It's a decision of the High Court of this year, and it really addresses 2 points: the authorisation of prosecution and confiscation under the Proceeds of Crime Act, and it also addresses the question of disclosure. Just to outline for you some of the background facts, this was an enforcement notice issued in relation to the conversion of 3 flats into 8 self-contained rooms. There was a guilty plea entered to the breach of that enforcement notice at the Magistrates' Court. The defendant originally wanted to argue the prosecution was an abuse of process because it was improperly motivated by POCA considerations. The Magistrates' Court ruled that it did not have jurisdiction to hear that argument, and so the defendant entered a guilty plea as a response. He was sent to the Crown Court for sentence and confiscation, whereupon he decided that actually he would like to change his guilty plea to not guilty and sought to have his guilty plea vacated. The Crown Court refused. And so actually the case of Kombu is about the judicial review of the Crown Court's decision not to allow the guilty plea to be vacated. Although that's the core of it, the High Court gave some very helpful comments and observations on the use of confiscation and POCA in authorisations to prosecute. We'll all be familiar, post the cases of Knightland Foundation and Woking Borough Council and Scott, that a decision to prosecute must not be influenced by the prospect of a financial benefit to the authority as the result of a confiscation order. The decision to prosecute must not be and must not appear to be motivated by a prospect of financial gain. In the case of Kombu, some of the facts that will be relevant. Before the prosecution that was authorised, the authority, through both its enforcement officer and its financial investigator, had identified there was in the region of £300,000 or so of benefit that had accrued because of the breach. The enforcement officer recommended prosecution on the basis that Mr. Kombu seemed to have really played the system. He appeared to have delayed enforcement action by submitting multiple applications. The conversion of 3 flats into 8 appeared to have been done for no other reason than financial gain, and the consequential result was 8 units of substandard accommodation. The authority had prepared a spreadsheet which identified a number of its current enforcement investigations, indicating which were to be considered for prosecution, and the Kombu entry was marked with the annotation POCA file to be reviewed. By the time it got to the head of service, who was primarily responsible for making the decision, the head of service considered the evidential test and the public interest test, identified that a number of matters, for example, the conflict of the development with local plan policies, the substandard nature and quality of the accommodation, and the use of applications as delaying tactics, in combination with the unlawful conversion being a priority form of offending for the authority, as being relevant to the decision as to whether it was in the public interest to prosecute or not. Under the heading Other Comments, so separate from consideration of the evidential test and separate from the consideration of the public interest in pursuing a prosecution, under the heading Other Comments, the head of service noted that they needed to check if POCA was being considered for this case. Elsewhere, the authority had obtained what are called production orders. These are court orders that require financial institutions to surrender financial information to local authority investigators. And subsequently, the authority authorised prosecution and laid informations at the magistrates' court. At that point, there was an email sent which had identified, an internal email, which had identified the authority having assessed the potential benefit of around £200,000, of which the authority expected to receive around £75,000 through the Home Office Asset Recovery Incentivisation Scheme. Now, putting all those facts there in front of us, we then ask, well, actually, was that a problem? The authority appears to have identified and concentrated on an element of financial benefit. There are emails discussing whether or not POCA was going to be pursued. There were emails identifying what figures might be payable, both generally and to the authority. And there was a spreadsheet specifically marking this case and raising it as a question for POCA. Ultimately, actually, this was not a problem. At the Crown Court judge found that the evidence showed that although there was an awareness within the authority's planning department of a possible POCA order from successful prosecution, and that preceded the decision to prosecute, and that there was no doubt there had been discussion, not only with the planning department, but also with financial investigators, about the possibility of a POCA order and what sum. Nevertheless, the court formed the view that the decision that was made was not motivated by or influenced by a desire to gain from a POCA order. The Crown Court drew a distinction between an authority that is aware of the possibility of POCA orders and an authority which is influenced by the possibility of confiscation and POCA. At the High Court, the court observed that it will often be necessary before a decision to prosecute is taken for local authorities to consider the possibility confiscation might be brought. It might, for example, be necessary to consider an application for restraint pursuant to the Proceeds of Crime Act. Those, you'll remember, are the orders that can be used to freeze bank accounts or to prevent the sale of assets before confiscation proceedings are finished. And also, it may be necessary for an authority to consider how it allocates its limited resources as between a variety of investigations. And the High Court very helpfully, I think, said this, that there is a crucial distinction between investigators legitimately considering the possibility of confiscation proceedings as against a decision maker being improperly motivated to decide in favour of prosecution by the prospect of financial gain to the authority. The court observed, again, I think very helpfully, that ensuring compliance with enforcement notices is the primary aim of this legislation, but it is not the only permissible consideration. And the court observed that otherwise it would be perverse, because a property owner might then be allowed to breach for as long as possible, maximise their profit, and then simply belatedly comply with the enforcement notice to avoid both prosecution and confiscation. And the court also observed that in deciding whether it's in the public interest to prosecute, it may well be legitimate to consider whether the breach of planning has resulted in financial benefit, of which the offender might be stripped by the court but would otherwise be able to retain. I'm going to pause there to observe for you that actually this is reflected in the Crown Prosecution Service Code for Crown Prosecutors. The CPS Code expressly identifies both premeditation and the extent of any financial benefit from offending as being specific matters that relate to the assessment of culpability in considering whether it's in the public interest to prosecute or not. If you want the reference for that, when you look at the Code for Crown Prosecutors, you'll find paragraph 4.14, brackets B, paragraphs 2 and 3. That point is not discussed in Kombu. It wasn't discussed in any of the other authorities and doesn't appear to be discussed currently in any relevant authority. But it is a fact that the CPS Code for Crown Prosecutors expressly identifies consideration of extent of benefit from offending as a specific matter pointing towards culpability in favour of it being in the public interest to prosecute. There is an important distinction to remember between the CPS and local authorities as prosecutors. With local authorities, there is the potential for the asset recovery incentivisation scheme to give rise to a serious conflict of interest, or at least the appearance of the same. But the court reiterated that the yardstick, when you are considering the suggested appearance of an improper motivation, is what is the view of an observer who is both fair-minded and informed. If the fair-minded and informed observer will form the view that a decision to prosecute is one which is simply informed of the issue of financial gain, that is likely to be a proper decision to prosecute. If, however, the fair-minded and informed observer would form the view that the decision to prosecute is one which was influenced by the issue of financial gain, that is likely to be the wrong side of the line. So in terms of guidance on how to properly consider Proceeds of Crime Act, being informed by it is perfectly acceptable. Indeed, you may have to be informed of it if you're considering restraint orders, which can be issued and pursued prior even to a charge being laid at court, let alone before a conviction is obtained or confiscation orders are commenced. But being influenced by the possibility of POCA is not acceptable. It's not going to be enough for an authority simply to say this decision is not influenced by POCA. If the underlying material, emails, etc., clearly show that POCA really is a driving force behind the prosecution. I think this is going to remain a fine line for now still. I don't expect these arguments are going to go away. But what Kombu does is provide helpful guidance on how to treat POCA considerations appropriately in a decision-taking process. The distinction between informed and influenced might not always be immediately clear, and I think that authorities can expect to continue to be challenged regarding this, and as a result should ensure that their decision-taking processes are clear as to the reason or reasons why prosecution and Proceeds of Crime Act are being pursued, and the role that awareness of POCA has played in an authority's handling of an enforcement matter leading up to a decision to prosecute. You'll have noticed that in Kombu, and also in other cases, the Knightland Foundation and Wokingham and Scott, internal documents, emails, spreadsheets, memos, other forms of correspondence have formed a large part of the basis of the defendant's applications in these matters. How is it defendants get these emails? That brings us to the second problematic area for prosecutions, and it's another matter that was also discussed in Kombu, and is the question of disclosure. If you read the judgment in the case of Kombu, it's apparent that the local authority there had failed to comply with orders to make disclosure of various pieces of information. It has a particular pertinence in relation to authorization to prosecute and POCA, where documents or emails that discuss or mention this are likely to fall to be disclosed. There's a slightly bizarre moment, it seems, in the decision in Kombu where the situation where the judge in the Crown Court appears to be presented with some 3 lever arches of material for the judge to decide on disclosure. I'm going to start by reminding, hopefully something which doesn't need reminding of, but that the obligation to disclose is on the prosecution, with the ultimate responsibility on a decision on disclosure being that of the prosecution advocate in court. And we are not here talking about disclosing the evidence that is used in the case. We are talking about disclosing material that is not evidence, things that are outside the evidence in the case, your file notes, your internal memos, emails, discussions, letters, notes from site visits, photographs that are not being used in the case, that sort of thing. There's a duty on the investigator to collect and to record and retain all material encountered in the investigation, irrespective of whether it forms part of the evidence or not. And if it's not evidence, i.e. it's not part of your case when you get to court, it should be on a schedule of unused material. And looking at that material, that unused material, if any of that material might reasonably be expected to undermine the prosecution or to assist the defence, and that includes not only in actually making out their case substantively at court, but it also included material that might assist the defence in making an abuse of process application or in mitigating any sentence, then it must be disclosed by the prosecution. And just pausing there, we can recollect back from Kombu the emails that were sent between various members of the planning and financial teams discussing elements of the prosecution, discussing elements of the confiscation and financial considerations. Of themselves, they don't necessarily assist the defence in setting out what a defence might be, but they clearly assist the defence in making their application that the prosecution is improperly motivated. Now, I mentioned that there's a moment where the judge appears to be presented with a large quantity of material. The only time a judge should be considering disclosure is if the material that you hold as a prosecutor you want to withhold, either because you say it's irrelevant or because it is sensitive material. And it's only at that point that a judge should be getting involved in making the decision. The obligation rests primarily and in an ongoing way on the investigator, who will likely also be the disclosure officer, who have their responsibility to collect and record and retain information. An obligation on the reviewing lawyer, typically the authority's lawyer, to make an initial determination of whether to disclose the material or not. And ultimately, the final decision rests on the advocate in court, because the advocate in court, whoever they are, has an overriding duty to the court. Failure to make proper disclosure in itself is a sufficient reason alone to stop a case from proceeding, irrespective of what else is happening in the case. Failures in disclosure are a substantial reason why cases are stopped before they reach the point of a verdict. And a final point, to remind that all of this material is likely to arise from the positive obligation that investigators have to pursue all reasonable lines of inquiry, whether they point towards or away from a suspect under investigation. And of course, the material that is discovered in those investigations all needs to be recorded, retained, and if appropriate, disclosed to the defence. I'm going to turn now to talk to you about some issues arising in connection with injunctions and discuss the situation post the Court of Appeal decision in the case of London Borough of Bromley against persons unknown and others, again a 2020 decision. This was a case where the London Borough of Bromley sought a without notice interim injunction prohibiting entry and or encampment in relation to all accessible public spaces in the borough, save for cemeteries and highways, which came to about 139 parks, recreation grounds, open spaces, and an additional 32, I think, public car parks. Although it was an injunction sought against persons unknown, that effectively was tantamount to an injunction against the gypsy and traveller community. And the court noted that 38 similar injunctions in other areas had previously been granted. The court refused to grant the wide injunction that was sought, and the Court of Appeal upheld that refusal on the basis that that approach is a disproportionate approach. Borough-wide injunctions, the court said, are inherently problematic because they give the gypsy and traveller community no room for manoeuvre, where travelling is a recognised and protected habit of their lifestyle. The effective blanket ban on gypsies and travellers is then potentially discriminatory for that same reason. And the period of time, this was a 5-year injunction that was sought, was problematic, particularly in combination with the wide area of effect. Now, the first point to observe is that Bromley is not a complete prohibition on wide area injunctions, but the court did emphasise that they are really a very last resort where there is no other solution to the particular problem. 2 points to bear in mind before we get into some of the practical considerations to have. Injunctions against persons unknown are exceptional measures, and the court reiterated this largely because if you are pursuing an injunction against persons unknown, that effectively removes an Article 6 right to a fair trial and precludes the participation of those persons in the court process. And the second point to bear in mind is the need to have regard to the cumulative effect of a number of such orders, including where other such orders have been obtained by other authorities. So it's not enough just to consider the effect of any orders obtained by the authority in question. They have to be considered in the round in combination with other orders sought by other authorities. The fundamental consideration after Bromley is going to be for local authorities demonstrating that the injunction that is being sought is compatible with the nomadic habits of the gypsies and traveller community. The blanket ban being discriminatory because it is not compatible with the nomadic habit of gypsies and travellers, because it seeks to exclude them from everywhere. Contrast that, however, against a more granular assessment of sites and targeting of an injunction towards vulnerable or sensitive sites. A targeted approach is less likely to involve an unacceptable constraint on a nomadic lifestyle, because the targeted approach will still allow areas for gypsies and travellers to use as transit sites. Orders which seek to, for example, protect environmentally sensitive sites or locally valued sites, prominent sites where the occupation of it will likely result in considerable disruption, or sites that have a long history of repeated incursions, are all possible indicators that the site may well warrant protection with an injunctive order. It's not going to be enough to simply suggest gypsies and travellers could go elsewhere. For example, that they might stay on private land, that they might be able to stay on highways, or be able to move to a cemetery, as was the case, I think, in the Bromley application. An authority is going to need to have evidence, credible evidence, evidence of what alternative sites or facilities are genuinely and reasonably available. If there are no transit sites and the authority has no proposals for transit sites, and there isn't really any support for the provision of transit sites in policy or in allocations, that's likely to weigh against the grant of an injunction. It's not necessarily fatal to an injunction application, but an authority is going to need to have credible evidence to support the position that no transit sites, for example, are necessary. Now, a recent GCAA might be the sort of evidence base that would begin to support an authority in that stance. The authority is also going to need to have appropriate policies in place to address the situation where stopping does occur. Even though a GCAA might show that there is no need, for example, for transit sites to be provided, the reality is that there will be at some point gypsies and travellers likely stopping through the authority. So a policy in how that's going to be dealt with by an authority will need to be evidenced and worked through in evidence before the court. But ultimately, the court noted this was an issue that arose because of the tension between the human rights of the gypsy and traveller community and the failure of authorities to make sufficient provision of transit sites. The ultimate solution, the court concluded, and I think realistically, is therefore going to be a need to make a greater level of provision of transit sites. One of the other matters that weighed in the court's considerations was the length of the order that was sought. It was a 5-year order that was being sought. So when authorities do seek these orders at court, evidence showing how the length of the order sought is proportionate to the harm or harms that are identified will be something that will need to be addressed for the court. And really, it condenses down to a need to focus the type and the extent of the restraints that you seek in your orders to the harm or the harms that are identified in the evidence that is used to support the application. Another main point that the court emphasised was the need, wherever possible, for engagement, and certainly engagement of at least some sort where possible. Evidence of there being engagement will considerably improve the chances of an authority in securing an order. Where, for example, an authority has undertaken an assessment of the likely effects of an injunction, accounting for the specific needs and vulnerabilities of those who are going to be affected by the order, that will certainly stand to improve an authority's chances. Likewise, the undertaking of substantive impact assessments and welfare assessments, particularly so when considering impacts on children because of the specific and freestanding obligation to have regard to the best interests of the child. And of course, for this all to be done prior to the pursuit of any kind of enforcement action, including obviously pursuing an order at court. The court also identified that it would give special consideration to the timing and the manner of the approaches made when dealing with an unlawful settlement in relation to alternative pitches and the impact assessments and the welfare assessments. Authorities will need to ensure that their approach to the occupants of a site and the evidence that is gathered as a result of their investigations and their assessments is not qualitatively compromised by the way in which they approach the occupants of the site or by the timing of their approach to the occupants of the site. And all of that will need to be shown in evidence. An authority is going to have to show that there has been engagement, that there has been assessment of the impacts. There will need to be evidence to show a particular need to protect the area or the areas that are identified, and to show what other availability there is, and that the order does not go beyond either the geographic area or areas, or the time period that is going to be necessary in combination with any other orders to achieve the desired effect, whilst not amounting to, in effect, a blanket ban. And being able to show all of those matters in evidence, I think, will be what increases, post-Bromley, a local authority's chances of successfully pursuing orders. This does mean, of course, that there will be circumstances where seeking an order simply is not justified because it is not proportionate. An example might be because, for example, of the impacts on the occupants in terms of their needs assessment, their welfare assessments. When weighed against, for example, the designations and protective designations of a particular site, that undertaking that balance, the balance does not fall in favour of seeking to remove the occupants from that site. The land itself might simply be insufficiently sensitive to warrant the order sought, or that the length of the order that is sought is simply excessive, either when taken alone or again in combination with other orders sought and obtained either by the same authority or by others. And I think that that element of having to consider the cumulative effect of orders that have been obtained is something which is going to feature more largely in considerations going forward. I think authorities should by now be relatively well versed and used to undertaking and the need to undertake impact assessments and welfare assessments, and particularly to have regard to the best interests of the child when making any decision as a public body that likely affects the interests of a child. But putting all of those together in combination with other orders that that authority has obtained, or more particularly in combination with other authorities that perhaps other orders that adjoining authorities have obtained, may take a little more getting used to and a little more work from the authority. But the upshot is there is not a closed door to wide area injunctions. They are going to be extremely limited in terms of the circumstances that justify it, provided that authorities have adopted an approach where they can show in evidence all of the steps that they've taken, and that the order that's being sought has been effectively and properly calibrated to be proportionate to the threat, to the area that is identified in terms of the harms arising from an unauthorised encampment. That is likely to maximise an authority's chances of successfully obtaining an order, whilst at the same time not impinging upon the protected nomadic habits of the gypsy and traveller communities. The key is going to be in ensuring you can show that an authority has had regard to all of those matters and can show the considerations and conclusions that have been had in evidence to support the approach that is being taken to the enforcement action in question and to the terms and type of order that is being sought from the court. That's a brief run through for you of some of the matters that have arisen recently in authorities in the High Court and Court of Appeal on prosecutions and injunctions. I think now we have some time available to us for questions and answers. So I'm going to hand back to Craig, who hopefully has some questions for us.
Yes, I do. Thanks very much for that, Scott. It was very useful and very interesting as well. Yeah, we've got a few questions that have come through, so we'll try and get through. We've got plenty of time, so hopefully we should get through them all. So the first question is, to what extent, if at all, do you think that that Bromley is impacting or impact on planning and enforcement appeals for gypsy and traveller sites? For example, is the supply of transit sites being more widely raised as a consideration? Does Bromley have implications for any injunction that may affect homeless people in the settled community, as well as gypsy and travellers? Does it mean that local authorities must have regard to human rights and equality considerations, injunctions in more generally? And there's a lot of questions there.
Well, I'll work through some of them, and feel free to prompt me if I've forgotten to address an element of the question.
Yeah.
I think the first point was asking about the potential impact and relevance of Bromley to appeal determinations.
Yeah.
And I think realistically, the considerations that are set out by the court in Bromley are really very likely to be considerations which an appeal inspector is already going to be seized of and apprised of in the evidence that they have in front of them. I don't think Bromley necessarily is going to raise any new issue or any particularly new way of considering matters for a planning inspector. I think what it does do is reiterate that there needs to be careful and more specific consideration of precisely why one or more particular sites needs the type or level of protection that is being afforded, and that there needs to be some understanding of balance. Certainly by the time you get to the court stage of seeking injunctions and orders, there needs to be some kind of balancing between the human rights and protected characteristics of the gypsy and traveller community as against the need to protect particular sites from unauthorised incursions and encampment. In terms of effects on the seeking of orders from courts more generally, I think what it does do is put down a marker for other courts to follow, and hopefully to that extent helps perhaps regularize a little bit the kinds of considerations that courts will have when they're being asked to grant these grant injunctions. It also, I think, hopefully requires authorities to make sure that they have really applied their minds to asking why it is they're seeking these kinds of orders for the areas they're seeking them for, and to really ask, does this particular encampment on this particular site really warrant the severe type of order that an injunction really is, or is it something which frankly is perhaps better mediated and addressed through the process of provision of further transit sites in the ordinary planning process. So I think what it helpfully does is, I think it probably likely does to an extent curtail the kinds of applications that will be made by authorities, because it provides courts with a much greater and firmer steer about the considerations they should have, and likely will cause a court to possibly have greater scrutiny of the applications that are made, particularly where they're coming in relation to sites that perhaps don't have any kind of protective designation or historic issue with incursions, and seem to be applications which are made really without proper consideration of the impact on the people who are being moved off of it, really for no other reason than they simply shouldn't be there, and really ask courts to ask applicants, to focus in on why they are seeking those particular orders. And does help to remind authorities that actually the solution to all of this should be that transit sites should be being provided in much greater numbers than really they are, which I'm sure politically will be a very unpopular situation for many authorities to find themselves in. But there is almost certainly, I suspect, going to be a correlation that can be drawn between the provision of transit sites and the likely need to go to court to obtain injunctions to prevent unauthorised encampments. Because if there are sufficient transit sites, then an authority really shouldn't be finding itself in a situation where it's repeatedly having to go and ask people to be removed from land. Yeah,
it makes sense, doesn't it? I remember an authority that I worked for where we had a huge problem with gypsy and travellers, and we didn't have a transit site, and at one point we were considering getting a injunction to cover a specific area in our location, because that's where the majority of the gypsy and travellers went. but we opted against it in the end because we felt that what was the harm being caused by it? And at the end, it felt that just by going to speak to them and say, how long are you going to be here for? Or we'll be here for a week. And then they left after a week, and it was thought, well, we'll just manage it that way. And I felt that was the best way of doing it. And I think it's like you say, you've just got to speak to them and talk to them and try and understand their circumstances before jumping in and thinking, I need to get an injunction here, because like you say, an injunction should be considered a last resort, and if it's not working, the methods that you've got then go for an injunction possibly. So, yeah.
Absolutely. The court was very keen to impress that engagement is absolutely necessary before seeking these kinds of orders, and particularly, for example, having regard to the best interest of the child and discharging of a public body's public sector equality duties are matters which have demonstrably been gaining traction in planning decision taking, both at first instance and before courts. And I think Bromley again reflects that further entrenching of the obligations that authorities have to really consider the impact of what they're doing before they make those decisions.
Yeah, exactly. Yeah, right. Another question here. Are enforcement/planning officers expected to undertake prosecutions and injunctions, or would it be a lawyer?
It's going to inevitably involve legal input at some point. Most authorities will they'll all draw their own individual lines as to which officer has which particular responsibility, but by and large, decisions on, for example, commencing legal proceedings either as a prosecution or as an injunction is going to be a decision that's going to be made by legal. I think for example, if we look at Kombu, the case I was talking about with prosecutions, there the officer made recommendations as to which cases they thought might be suitable for prosecution. That went to a head of service who undertook another review and made recommendations. But ultimately, the decision to prosecute in Kombu was a decision made by legal, and that's because there will be particular considerations relating to whether a prosecution should be brought or an injunction should be sought, which will require legal input into the same. That's slightly different from what we were talking about with the obligation in terms of disclosure, because there, investigating officers, who will by and large be the enforcement officer, who will also then have to double up as the disclosure officer, they have effectively a separate ongoing set of duties and obligations which are similar to but are different from the obligations imposed on the lawyers in the case. So obviously an enforcement officer there would be discovering information as they conduct their investigation. They have to record all of that information, and then when they become the disclosure officer, when the case gets to court, they will be they'll review the material because they know all of the material in the case. They'll review it, deciding whether they think that might help the defense in one way or another, or whether it might undermine the prosecution. But they at that point will then make the recommendation to the reviewing lawyer, and the reviewing lawyer, who is typically the authority's in-house lawyer, will make the decision as to actually what gets disclosed and what doesn't get disclosed. So they're sort of parallel obligations, but they do interlock. Ultimately, the decision on disclosure finally will be whoever the prosecuting advocate is in court, whether that's the local authority's lawyer who's gone to court to represent the authority, or whether that's a solicitor or a barrister that the authority has employed separately. Whoever the person is in court, who is the lawyer presenting the case, ultimately has the final say, because that person has overriding obligations and duties to the court when they're acting as a prosecutor that are distinct from working for their particular client at any one point.
Yeah, okay, brilliant, thank you. Next question. Where a borough/district council has obtained a prohibited order, is it possible for the county council to pursue a breach the same before the courts? Also, presumably the burden of proof in pursuing a breach of an injunction is on the applicant, but what is the standard of proof beyond reasonable doubt? or balance of probability?
You're going to have to satisfy a court, really satisfy it so that it's sure, or in old money, beyond reasonable doubt, as to the nature and extent of any breaches of an order, because you are ultimately really asking for someone to be sent to prison for a contempt of court, for breaching a court order. And that obligation will rest on the person who is making that allegation throughout. I'm not really certain why a different authority would be wanting to pursue an allegation of breach of an order. I'm quite certain that if a district or borough had obtained an injunction and genuinely believed that the person they'd obtained the order against had breached the injunction, they really should be the party who are pursuing the allegation of breach of that order.
Yeah.
I don't really see how, in those circumstances, a different authority would be able to justify standing in the shoes of a previous. It's not as if, for example, public authority A has been dissolved in some way and public authority B has taken over, where, for example, maybe there have been two tiers of authorities which have later become a unitary authority, where effectively you would just transpose the obligations from one authority to another. I think you would be looking to the district or borough authority to pursue and enforce their own orders.
Yeah, makes sense, doesn't it? Are you aware of any situation where an enforcement notice has been discharged at magistrates' court based upon the responsible party's defence that a breach of planning control has not occurred? In this instance, is it considered that the magistrates went against their remit in this regard as matters pertaining to which a breach of planning control should have been for consideration at an appeal and not at magistrates?
You've got a situation where, on the face of it, it looks like a conflict between what's being said at court and the operation of Section 285 of the Act, which insulates enforcement notices from subsequent challenge. And if someone is stood there saying to the court, well, what I'm doing is not a breach of planning control, it would be tempting for a local authority to say, well, that should have been a ground C appeal. And because it should have been a ground C appeal, you now can't raise it because Section 285 prevents you from doing that. The difficulty with that argument, of course, is that the prosecution will have to prove all of the elements of the offence to the court. And if you work through the processes, although all an authority is going to have to do is show that there's an extant enforcement notice and that the actions of the defendant are in breach of the requirements of that notice, there are two considerations to be had. Firstly, that an enforcement notice can't cut across matters which are already permitted. For example, I think we're all probably familiar with what's known as the Mansi doctrine, and the idea that we don't have to amend enforcement notices to account for permitted development rights. So an enforcement notice might prohibit, for example, a change in use of land, but it can't remove the operation of the 28-day temporary change of use PD rights that are applied by a statutory instrument. So there is still, even on that assessment, space for a court to form the view that actually this is not, the matters that are being said to have occurred are not actually a breach of planning control caught by the enforcement notice in the first place. And of course, the second element is to think of it in a slightly different way. You might be more comfortable as a prosecutor understanding that the defence that someone's done everything they can reasonably be expected to do to comply with the notice, including only doing things that are not a breach of planning control. So whether you want to frame it as something under either the Mansi doctrine or the inability of notices to remove, for example, permitted development rights, or whether you want to frame the same point as I'm only doing what planning allows me to do, which is having done everything I can reasonably be expected to do, I don't think either of those analyses are improper analyses for a magistrate's court or a Crown Court for that matter to have. And it would be proper, I think, in those circumstances for a court to refuse to convict on that basis. I don't think the court could be said to have overstepped the mark if, for example, to go back to our PD rights, if someone was saying, I've only used my 20 days out of my 28 days temporary change of use PD rights, even though the notice says don't change the use of the land, because the notice can't take away my statutory rights under the GPDO.
Yeah, okay, that makes sense. Okay. Do you always need a person's date of birth to prosecute? And what happens if you can't get hold of it?
You'll need to be able to identify with sufficient certainty the person that you're prosecuting, largely because you won't be able to arrest them and produce them from the police cells. So you're going to need to be able to sufficiently satisfy the court that the person that has come before them is in fact the person against whom the information or the summons was issued. When the court will ask them their date of birth when they first appear, and of course failure to provide the court with the information it requests is a whole other kettle of fish that defendants really don't want to get into. But as a starting point, you're not primarily, I think, going to be dealing with offences in planning prosecutions where the age of the defendant becomes a material and relevant consideration.
Right. Could you, if, say for argument's sake, you couldn't get it and you really need to get it, could you put that in a PCN or anything on those lines, or would that be completely inappropriate to do that?
PCNs can be used to discover the identities and contact details of persons who are either operating or occupying the land or who have a material interest in the land. So there isn't anything inherently improper with asking for names, dates of birth, contact addresses, and other methods of contact for any person who owns or occupies or has an interest in part of the land to which the notice relates.
Right. Okay. Are there any alternative measures for carrying out PACE interviews while face-to-face is not appropriate?
PACE interviews by correspondence have a very long history and are very well used, particularly in planning investigations up and down the land. That they have their own advantages and disadvantages. In the current climate, not being able to conduct a face-to-face interview means that probably the pros and cons of a correspondence PACE interview, the balance and consideration of those has probably changed quite a bit, because it'll be likely the only way you can realistically obtain that kind of information, unless you're in a local authority setup where you have some particularly good safeguarding measures which enable you to conduct socially distanced interviews in person in an appropriately safeguarded way. But working on the assumption that that's a bit pie in the sky, in interviews by exchange of correspondence, where there's a formal PACE warning and the questions are set out formally in a letter with a requirement for a response, and of course making sure that the person who gives the response is either the individual who you're seeking to identify, or if you're to interview, or if you're interviewing a company, someone who is suitably positioned and approved to give answers on behalf of the company, then that will be fine. There's absolutely no problem with interviews by correspondence, and I think if putting aside their ordinary drawbacks, they're likely to actually be the only way you'll be able to conduct them for the foreseeable future, almost.
Yeah, obviously I've got to do one as well, and our offices have made it all COVID secure, and some of the rooms have got big screens in between the desks to enable interviews to be done. But I still sort of feel uncomfortable, and potentially the other side feel uncomfortable by doing it, and that's completely understandable. So
yeah, I mean, you have to accept that there will likely be reasonably good justification for many people not wanting to come into a council building to sit in a room they know nothing about and be interviewed about various matters. Because again, going back to what we were talking about before, touching on it a little bit, of course, the authority doesn't really know much, I suspect, of the personal circumstances of the people they're seeking to interview, whether they're shielding, whether they have particularly vulnerable people that they're living with or who are in contact with them, those kinds of things.
Yeah, yeah, okay. Do you believe that the backlog in court cases will result in undue delay, it being cited as a defence in prosecutions?
I think it is something which is causing very real concern. It's a huge backlog, both in magistrates and Crown Court, and it is a backlog that is only growing. And we are all familiar with where many courts tend to prioritise other kinds of criminal cases as against planning matters in court. And there will, I suspect, come a point where there will be a valid argument to be made that the delay is simply an unconscionable delay, such that has prevented someone from having a fair trial. These kind of things typically only actually tend to gain traction where that delay has had some palpable effect or consequence for a defendant. For example, evidence no longer being available, witnesses no longer being available, those kinds of things. Because by and large, many other material considerations, if someone's circumstances have considerably changed since the decision to prosecute, then a remedy may lie in revisiting the decision to prosecute in the first place, or if pressing ahead, then that can be reflected in any sentence that is ultimately ordered by the court. And also very often courts express displeasure at a prosecution being pursued in their award of costs for a prosecutor, and sometimes will refuse to award costs entirely in a case where they think that a prosecution is unmeritorious. So I think it probably will have the effect of causing some authorities to consider or reconsider some of their prosecutions, because it may well be that the balance of material considerations going to the public interest may have changed because of the extreme delay. Whether it actually has a practical effect immediately at court, I think is probably less likely, A, because there'll be a lot of cases suffering that kind of delay, and B, because, as I said, they don't really seem to gain any traction until there's a palpable consequence for a defendant and their case. But I can't, unfortunately, see the backlog, like with the inspectorate's backlog of enforcement hearings and inquiries. I can't see these backlogs being cleared in any great hurry, because I can't see at the moment where we'll reach a point where a return to previous ordinary types and levels of working will happen. And B, of course, when that does resume, it's only going to be a return to ordinary levels and throughputs of cases. It's not going to be an extraordinary throughput of cases to clear a huge backlog. So there's going to be, I think, some considerable delay for a very long time in both court proceedings and probably in terms of planning appeals as well.
Yeah, I know our legal department said we've got a number of prosecutions, but they sort of said, well, there's no point doing the threatening somebody with a prosecution when we can't actually go forward with it at the moment. So try and resolve the breach as much as you possibly can. Yeah. And if you can't resolve it, then you'll have to, but try your best at the moment. So
yeah, I'm instructed in a number of matters at the moment where even the first hearing of a case has been put back and back and back, and it has gone months and months and months back, because the court simply doesn't have the capacity for people to turn up and enter their pleas. And the chances of actually getting a trial listed at the moment are virtually nil. There is virtually no prospect of trials being listed at the moment.
Yeah, we've got a last couple. I know we're conscious of time, but hopefully we should be able to get through these ones. I'd like to understand Scott's thoughts on the paradox between the purpose of enforcement action not meant to be punitive. So just another line, scroll me up. Punitive and prosecution, which is inherently punitive. The punishment of successful prosecution does not itself resolve the breach of planning control. Did you get that, or do you want to say that again? Sorry.
Yeah. So I mean, the underlying idea, I think, of enforcement action being to secure compliance with planning controls, and is not of itself intended to simply punish people, as against, well, how do we reconcile that with a prosecution process where at least part of the sentence is intended to have a punitive element to it, and of course the direct outcome of a prosecution is not going to be an order for someone to comply with planning controls, because it's never going to be, because the court doesn't have the power to make those kind of orders. It'll just impose financial or other penalties against individuals. I think the part of reconciling those against each other is understanding that the punitive element of sentencing is only one element of a sentencing process, and that actually the purpose of pursuing prosecution really will still primarily be to seek, albeit indirectly, to achieve and secure compliance with planning controls. The idea being, I think, that people will comply with planning controls in order to avoid being prosecuted, or once prosecuted and fined, will then comply with planning controls as a consequence of being prosecuted and penalised. That it's simply another route through to securing compliance with planning controls. There are, of course, other functions, although not primary functions, but it is important to ensure that planning enforcement has a sufficient range and depth of enforcement mechanisms that allow it to demonstrate and practically enforce the integrity of the planning system and the applicability of planning rules to pretty much everyone, hopefully in as equal a way as possible. And that a number of different tools will be needed, because there are any number of different situations and ways in which planning rules and regulations can be broken and impinged upon. And it's not necessarily going to be the case that everything will warrant an injunction, but in the same way, not everything is necessarily going to warrant just a sort of a stern word on the site with someone who really has absolutely no interest in doing anything. And of course, as the court observed in Kombu, there is a permissible and practical consideration when considering the public interest of asking whether or not a person should be ultimately able to retain financial benefits that they have obtained in breach of planning controls and in the course of committing a criminal offence. So there are other considerations rather than prosecution simply being a punitive measure. It is ultimately still something which is intended to achieve the compliance with planning control. It just isn't. It's a slightly more circuitous route of achieving it than perhaps simply getting an injunction requiring someone to do something by this date. I mean, remembering, of course, that prosecutions are premised on the back of an extant enforcement notice. So the prosecution is about trying to ensure compliance with the notice. It's not just about punishing someone for not having done what they were supposed to do.
Yeah, okay. Doesn't asking for a date of birth and a PCN breach data protection rules? No, we just.
Oh, we all love a data protection question. No, is the short answer. I'm not sure how it would be suggested that it is breaching data protection rules. I mean, an authority has a legitimate interest in obtaining that kind of information, and I'm assuming that once it's obtained that information, the authority is not going to be processing that information in an inappropriate way or dealing with it in a way that is impermissible under the data protection regulations, the GPDR, because it's going to be something which almost certainly is going to be a precursor to, if not already part of, a substantive criminal investigation, because you'll be serving a PCN because you're likely investigating a suspected breach of planning control.
Yeah. What is the status of evidence if it takes too long to get to court and the evidence is then more than 6 months old?
I think the question is perhaps slightly confusing two issues. there are time limits on certain types of offences, in that summary offences ordinarily have to be commenced as proceedings at court within 6 months of the commission of the offence, although there are various exceptions and alterations to that 6-month time limit, many of which actually are relevant to planning prosecutions. And that 6-month time limit just doesn't apply to anything that can go to the Crown Court. So, for example, breach of an enforcement notice, the 6-month time limit is irrelevant. And of course, the 6-month only starts from the point that the offence finishes. So, for example, if someone is in breach of condition in a 12-month period, the 6 months doesn't start at the beginning of the 12-month period. The 6 months starts at the end of the 12-month period, because that's when the offence is finished being committed. So that's sort of the relevance of the 6-month time limit. The issue of evidence that is outside of, for example, a relevant time window for a prosecution being commenced. Well, if you are in a situation where you have one of these time limited offences and some of your evidence goes outside of the relevant time limit for your offence, then you'll have a few things you'll want to ask yourself with actually what it is you want to use that evidence to show. It may well likely not go towards providing evidence of commission of the offence because you're outside of your time limit. But depending on the kinds of offence that you're talking about, and it becomes difficult at this point to keep talking in generalities, but it may well be that kind of evidence you might want to think about as effectively being a form of bad character evidence, something which shows a propensity, for example, in the past, although it would be the recent past, to commit certain types of offences, or as important explanatory evidence which sets a context for the allegations that are made within time. So it's not necessarily the case that a line is sharply drawn at a 6-month point. But of course, that's only really going to be relevant where you are dealing with one of these kinds of offences, which is very strictly time limited anyway.
Yeah, okay. Final question. It relates to a site in a settlement village. Unauthorised works have been carried out through lockdown on wasteland in the centre, which borders to an established residential housing estate. Works have been to erect a 8-foot plus wall on land, hard standing concrete bases and electric points and lighting columns for the establishment of a traveller site. We have served an enforcement notice to reduce the wall to PD, which was followed in 2 days by a planning application to retain the wall. How do we justify an injunction?
Well, you'll primarily want to go and look at the judgment in Bromley, because that will set out for you, obviously in more detail than I've been able to do just in going through the main points in this talk. But in that instance, you'll want to be looking at what is the nature of the site? Is it an environmentally sensitive site? Is it something which is particularly prominent where the occupation of it is going to likely cause disruption? Is it a locally valued site? Is it a site that has a history of incursions, for example, where there have been lengthy and expensive cleanup operations afterwards? Is it a situation where the authority can show, for example, commission of criminal offences? Typically fly tipping offences would be something that authorities would want to rely on in these kind of circumstances, and try to show that there has been an increased incidence in Environmental Protection Act offences at a point in time when either this particular site or sites in this area have been the subject of unauthorised encampments, because a demonstrable increase in criminality associated with the occupation of the site is something that the court mentioned in Bromley will be one of the factors that will tend to point towards the grant of an injunction. Of course, you're going to want to engage with the occupants of the site, or the intended occupants of the site. You're going to need to fathom what their needs, their vulnerabilities, particularly in relation to any children, and perform a balancing exercise of those 2 points, and consider what other sites are available within and around the authority area, and whether they're turning up on the site because of the effect of other orders already granted to other authorities that have effectively pushed them to this site in the first place, because that may be something which points away from the grant of an injunction, particularly in circumstances where there's no particular environmental or other protective designation for the site in question. There is a legitimate issue which will need to be explored in evidence and dealt with in submissions at the court about how and why the enforcement notice was served and the stage at which that is progressed to, and what the consequential effects would be of that as well. I'm assuming the enforcement notice will result ultimately in an entirely cleared site because the requirements would be to clear the site. So if that's relatively advanced, that may well be something that the court is prepared to say, well, we'll just wait for see what the outcome of an appeal against the enforcement notice is. Whereas if that's at a very early stage and you're in a situation where perhaps not all of the site is occupied or built out, the court may be prepared to say, well, it's actually better to prevent many of them moving to the site in the first instance, rather than act in a way which is entirely responsive to a site that's already been fully occupied. So there are a number of considerations that'll be relevant for the authority in that circumstance. I can't necessarily say that it sounds like one where there's a particularly strong indicator one way or another. There's going to be a lot that will depend on the engagement process and what arises from the engagement process, and what the situation is with provision of a credible alternative other available sites and other orders obtained by other nearby authorities.
Yeah. Okay. Well, I think we've answered all the questions that have come in. So thank you very much, Scott, for your time this afternoon. Very useful. Yeah, that will be the end of the webinar. So thank you very much, everybody, for listening, and stay safe. And we'll speak to you soon. Thanks very much. Bye.
Thank you very much.